Hello, my name is Grant Fritchey. I work for Redgate Software. Hey guys, let's talk about the California Consumer Privacy Act. It's actually now the California Consumer Privacy Law. It's been passed. It's all in place. And so here's the deal. Enforcement of this law starts in January of 2020. That is 9 months away. Only 9 months. Are you already working on ensuring that you are in compliance with this law? If not, you may want to. Now, it's a good chance maybe you don't have to worry about it, but let's ask the question. Who does this law apply to? Well, if you read the law, throughout it talks about consumers' personal information. It says it over and over and over again. It's a term of art. Look, I'm not a lawyer. I'm a nerd. But it's a term of art that they use over and over again, consumer. But if you get to, all right, hang on a second. If you get to section 1798.140, paragraph G, yeah, this is a lot harder to read than the GDPR, I'll tell you. If you get down to there, you will find that consumer means a natural person who is a California resident, as defined in section 17014 of Title 18 of the California Code of Regulations. That section read on September 1, 2017, however identified, including by any unique identifier, whatever. Anyway, natural person. So consumers means a natural person. So it applies to the private information of a natural person within the state of California. So if you have data that you are managing of a person in California, you need to be in compliance with this stuff. If you, the stuff they have to be in compliance with is the right of Californians to know what personal information is being collected about them. The right of Californians to know whether their personal information is sold or disclosed and to whom. The right of Californians to say no to the sale of personal information. The right of Californians to access their personal information. The right of Californians to equal service and price even if they exercise their privacy rights. In other words, you can't, if you say like, look, I don't want to have to pay for anything. I mean, I don't want you to have my data. You can't say, well, there's one price for people who give us data and one price for people who don't. Which isn't really cool. It's not very nice. I mean, come on. Cut us some slack here. Anyway, you've got to worry about all this stuff if you're collecting information on consumers, natural persons, from California. Not if they're from California, but they're in Maryland or whatever, you don't need to worry about it. But it's if they are in California and you are collecting their information, you've got to sweat it. So are you on top of this already? If not, you may need to. Now, there are some exceptions as to which businesses it applies to. So the exceptions are pretty extensive. So again, we're still in the same section that talks about what a natural person, a consumer is. They also define a business. Now, business is, and it goes into the sole proprietorship, blah, 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 blah. That's not the interesting bit. It's the subsections below that really matter. And so we have to say, has a gross revenue in excess of $25 million. So if you're a small company, maybe this doesn't apply to you. Alone or in combination, annually buys or receives for business, personal, commercial sales, or blah, 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 blah. Personal information of 50,000 or more consumers. So if you've got a 50,000 person mailing list, but you're below 25 million, doesn't matter because it's the 50,000 that gets you there. If you derive 50% or more of your revenue, period, from selling consumer personal information, it applies to you. The data under management is also identified. You have to follow that too. It lists out what personal information is, and it's extensive list. I mean, it's identifiers such as your real name, your alias, postal address, any kind of unique personal identifier, online personal identifier, internet IP address, email address, account name, social security number, driver's license number, passport number, or similar identifiers. Hey, Further, personal information defined, it's healthcare stuff. Characteristics of protected classifications under federal law, under California or federal law. Commercial information such as personal property, products or services purchased, obtained, or considered, or other purchase or consuming histories or tendencies. Biometric information. Internet or electronic activity, including search history and browsing history. Geolocation data, audio, electronic, visual, thermal, olfactory, or similar information. Thermal. How red is my face is private information. Professional or employment-related information, educational information, especially. Then, of course, there's FERPA on top of that. Inferences drawn from information such as subdivisions. This is all back to that whole thing of like identifying information is not simply the one piece of data, you know, male or female, but it's also male or female and attended a session at SQL Saturday thing. Wow, suddenly, bam, we can identify the individual very quickly. So they're talking about combination and inferences of that information can also be used. In addition to all that, there are additional exceptions. I mean, a whole bunch of things like you don't have to do anything that makes you violate federal law. You have to still comply with civil and criminal law within the state of California. You have to, you know, stuff like that. Where'd it go? It doesn't require you to violate, you know, HIPAA or any other healthcare information. So basically, all those laws that you don't have to worry about. There's also a protection for people who are operating, charity. There's protection for people who are operating a charity. So there's a lot of exceptions around this. But if you're not figuring out your risk assessment and whether or not it applies to you, and you know, okay, great, you're below 25 million and you don't make half your income selling personal data, and you have less than 50,000 people on your mailing list, right? You've got all those things that get you out of this. That's cool. By the way, how about Washington State? Because they've got a new law too. Now that one doesn't take effect until 2021, so you got a little bit of time there. But look, less than 9 months. You've got to do the risk assessment. You've got to identify whether or not this applies to you. The California law is in effect, and enforcement starts January 1, 2020. You don't have much time. If you are covered by these, if you have a 50,000 person mailing list, if you make more than $25 million, if you make more than half your money selling or processing or by processing information, guys, you've got to get in compliance with this, and it is a full-blown GDPR-styled law that requires a heck of a ton of work from you, the data pro. So you better get on this, get it in front of your management. If they're not already on it, if they're not already aware of it, if there's not already stuff raining down on you to get ready for this, you better get up and start pushing up from below so that they're prepared, because it's coming. Please hit that like. Please hit that subscribe. My name is Grant Fritchey. I work for Redgate Software.